62B District Court is now in session with the Honorable Amanda Sterkenburg presiding.
Good afternoon, everyone. I have someone appearing on my screen as Jorge's Galaxy. Are you Jorge Enriquez? Yes?
Yes, ma'am.
All right. And I see Angela Holton on here, but I don't have that name on my docket. Is there a co-tenant with you, Ms. Holton?
Yes, Jorge Henriquez.
Oh. Okay. I have Ms. Holtzlander Evans present in the courtroom. Do I have any other tenants that I did not name? Raise your hand. I got 12 boxes on my screen. I don't see any other tenants. Okay.
Judge, was that tenant in the courtroom, last name Evans, was that a short south case with Attorney Todd Stewart?
I have Kevin Sutherland on it. It's a short south case. It's Holtzlander Evans.
Okay.
And we'll call that case first. The court is calling the case of Short South Realty Group versus Rosa Holtzlander Evans, 1-3398LT. Ma'am, you want to come up to the left?
Attorney Kevin Sutherland, P8 1681 on behalf of Short South Realty.
Good afternoon, Mr. Sutherland. And you are Rosa Eda Holtzlander Evans?
Yes.
All right, I'm Judge Sterkenburg. You are here for what will be the first of two or more landlord-tenant hearings. We call these summary proceedings. It's the landlord-tenant division of the 62B District Court. If you are going to have another hearing after today, the court will advise you of the date and time that you need to come back before you leave today. No judgment will enter unless the plaintiff dismisses the case without conditions or you are both represented by an attorney. Because no judgment will enter today, you will have at least 7 days to find financial or legal assistance. If you do not appear at the next hearing, a default judgment may enter against you. Other potential case outcomes include a dismissal, a conditional dismissal, a consent judgment, or the court might set this matter for trial or mediation. In landlord-tenant court, you have the right to have a lawyer represent you. The papers you received should have instructed you on how you could contact legal aid. You can speak with legal aid of Western Michigan. I do have a representative standing by. If it sounds appropriate, I will let you speak with him. You may contact the Grand Rapids Lawyer Association referral program or visit our legal assistance center here at the 62B District Court. We have a number of written resources there for you. If a judgment is entered in this matter, you will have 10 days to pay the rent, the court costs, to move or to appeal this court's decision. COVID emergency rental assistance may be available to you. Assistance may be obtained through the local coordinated entry agency, HARA, the Housing Assistance Resource Agency, or from the Department of Health and Human Services or Federal Help for Homeless Veterans. You do not need a judgment to obtain COVID emergency rental assistance or to apply for assistance with DHHS. The paperwork that got you here is sufficient. Lastly, if this matter can be resolved through mediation, the Dispute Resolution Center of West Michigan may be an alternative for you. If you have any questions, I will try to answer them to the best of my ability. You are not represented by counsel at this time, correct?
No, I am not.
All right, this is a non-payment of rent complaint to recover property. The court has been provided information that indicates rent to retain possession is currently $511.73, including court cost of $217.72. The plaintiff is seeking a possession judgment of $729.45. As to the rent and costs owed, ma'am, do you have any reason to believe those numbers are incorrect?
Yes, I do.
Okay. I received a packet that I think you dropped off earlier today. I have not reviewed them. At this hearing, I will not review them, but they will be in the file for use if we need them at a later date. What specifically regarding the amounts of rent do you contest?
Pretty much all of it. I'm being charged for maintenance, fixtures and stuff at the house that was supposed to be fixed before I moved into the property. That's why I dropped off the documentation.
Can you hear her, Mr. Sutherland?
Not very well, Your Honor. If she could speak up a little bit.
Yes, please, and just lean into the microphone.
Okay,
Mhm.
that's fine. I do disagree with the amount. I dropped off the papers to you yesterday. I was hoping you were gonna be able to look over it, but the charges that I am getting, are for things that were supposed to be fixed before I moved in. In the packet that I dropped off to you, and I also have copies right here, they specifically say in there 4 days after I moved in, hey, this stuff wasn't fixed. It took them 7 months to finally fix it. And then when I did get it fixed, I'm being charged for stuff that wasn't fixed before I even moved in. And then also, I was told by maintenance on a couple different of these charges that I wasn't going to be charged because it wasn't my fault that it was broke. For example, the bathroom faucet, one of the faucets were loose and it was causing extreme water to come out. I contacted John on Friday, nobody got in until Monday to fix it, so the water was just pouring in. When maintenance came in, he tried to turn the knob to turn it off, which caused it to bust. Maintenance told myself, and my son was there, and my son's father said, when I turned it, it busted, you guys aren't gonna be charged for this. But when the maintenance fee came in, it was $80 some odd.
Okay.
And then also, for, I believe it was 3 months, I was informing John, putting in maintenance requests and everything, that our furnace through the whole winter, for the whole, I think it got fixed last month finally. So as of September, finally somebody came in April and fixed it. The furnace guy said it was 2 filters that were the wrong size taped together inside of the furnace. And we couldn't get to it, it had a lock on it, he had to rig it and stuff. And through that time, my heat would cut off in the middle of winter at 3 o'clock in the morning, and I would wake up and it's 52 degrees and it's freezing. And I informed John over and over and over, and it took months for him to fix it. Excuse me. So I don't agree with the charges at all.
Okay. Well, then
Your Honor.
a second question. Oh, yes, Mr.
Just an opportunity quickly to respond. I know we're not going to get into too much detail today.
Mhm.
I think ultimately, when I'm looking at the entire damages assessed in this account since she moved in September, the total is $263.44. She would still have a balance that would have been due and owing, notwithstanding, even if I take those out of the calculation. It took about 3 months for the tenant to actually switch utilities over. So there were utility charges assessed, and the only payments that have come in on this account are through MISTA. So there's been no additional payments. I did see an addendum to the lease amounts addressing the furnace and a reduction in rent that was going to be effective and has already taken effect. So some of these issues have already been resolved. I think in this judicial efficiency, I would just simply ask that she reduce what she's got in terms of an answer in writing. It puts us on notice on what her position is. In a way, it just prevents us from having to keep moving the goalpost. So I would certainly want to follow up by the next hearing, I assume in about 7 days. If we could have an answer due by the next hearing, I think that would be helpful. But keeping in mind that with utilities never being switched over until late December, there was still a minimum amount owed.
Okay. Thank you, Mr. Sutherland.
Can I say something else?
No, because we're not going to litigate this issue today, right? There may come a time when everybody puts their testimony on the record as to whether or not this happened or didn't happen, or at this time or not this time, but that is not today. And that's why he said he understands we're not going to get into too much detail. What we are going to do is set this for another hearing. My second question to you was, are you seeking any financial assistance for your rent at this time?
I do receive MISTA payments.
Mhm.
That was the other thing that I was gonna mention. She said not to get into it. They're
You receive MISTA payments. Are you seeking like COVID emergency rental assistance or anything through the DHS in terms of supplemental resources for your rent?
No,
Okay.
because I actually spoke to my section 8 worker who said that when she did her tallying up, I actually should have a positive balance of over $900 with them.
Okay, all right, so then we will set this for another hearing. It will be in, we'll set it for 7 days. It'll be May 21st at 1:30 in the afternoon. We're gonna do a couple of things, though. Mr. Sutherland indicated he would love it if you would reduce your packet to an answer. And that's probably procedurally a fair statement. So what you can do is condense these text messages into a response that answers each of the allegations on the complaint. So it says, for example, the non-payment of rent, the rental rate is this, you owe $608.73. If you write down why you believe it is a different amount, you can file that with the court and the court will accept it. You'll have to send a copy to Mr. Sutherland. He'll have that as your answer to the complaint. That's what he was saying. And the court will accept that as an answer. So the reason I'm not getting into these at this time is because they haven't been, I don't know the foundation for them. I don't know the information. We're not having a trial today, but we might in the future. It starts with you filing your answer. So we'll ask you to do that. We'll send out a notice. You'll come back for another hearing on May 21st at 1:30 in the afternoon. In the meantime, I am going to let you have a conversation with Mr. Henry, who is with Legal Aid of Western Michigan. He's here. Mr. Sutherland, is there anything further on this matter?
No, Your Honor. I was just going to suggest legal aid to give her assistance on the pleadings. Thank you.
Yep. So we're gonna do that for her. Ma'am, I'm going to give you a copy of this notice. So that you know when you're going to come back. And then after I give you this notice, I'm going to have you go out of the courtroom, turn left, and then turn left again. You'll be in a conference room. There's a laptop in there. Mr. Henry is from Legal Aid. He'll appear on the laptop through Zoom and speak to you, and you can give him a little bit more detail and information into your matter, okay? All right, you may approach.
Your Honor, just last thing, if I could get a copy of whatever packet the court's been provided so I have the same information, I would greatly appreciate that.
All right, so Ms. Holtzlander Evans indicates she'll drop off a copy of the packet at the time she drops off her answer.
I'll stay tuned. Thank you. Appreciate it.
Thank you. All right, out, left, and left.
Thank you.
Thank you. All right, Mr. Henry, watch your screen for an invitation.
So I just want to make sure that, because Matt said that was what. And then go ahead and sign them. For Matt.
Thank you, ma'am. You are welcome. All right, the court is calling the case of Lighthouse Property Management versus Jorge Enriquez and Angela Holton, case number 21-3397LT. Mr. Henges, do you appear on this?
Yes, Judge.
Good afternoon. And I have both Mr. Enriquez and Ms. Holton present, correct?
Yes, ma'am.
All right, this is a termination case. The plaintiff brings this action having terminated the tenancy by notice to quit. I'm going to review the complaint. All right, no other provisions are noted on the complaint then. What are your intentions, Ms. Holton, Mr. Enriquez? You've been notified that your lease is being terminated. Do you have plans to move?
Yes, ma'am.
Yes, ma'am.
When?
That's still in the works, ma'am. We paid about $5,000 worth of rent that was due due to COVID, and I was on hold for a while. And within a week of us giving up all that money, we received that notice. So we're just trying to round up first payment and first month so we can move somewhere else.
And the court has been provided information that total rent due is $2,375, including court costs. In addition to possession, the plaintiff is seeking a money judgment of $2,615.36. Is that correct, Mr. Henges?
That's correct, Judge.
All right, my analysis of the Administrative Order 2020-17 requires a second hearing even in termination cases, Mr. Henges.
That's my understanding as well, Your Honor.
I hear different things, different places. So, but for today's purposes, we are going to set this for a second hearing. It'll be May 21st at 1:30 in the afternoon. You heard me go over the rights with the young lady who was just here, correct?
Yes, ma'am.
All right, if a judgment enters against you, you will have 10 days then to pay the rent. You'll have 10 days before the landlord can seek a writ of eviction. I would do all you can to work out your housing situation between now and the next hearing, and potentially then you can resolve this matter with Mr. Henges when we meet next.
Yes, ma'am. I do have one question, ma'am.
Yes.
Is it possible we could set the court date for early in the morning? I just started a new job and I had to take the day off at the moment it's court appearance. And it's counting against me. I'm at work. I don't want to lose that job and be back at a square one. You know what I'm saying?
Do we have any morning appointments that day? Mr. Henges, could you do a 10:30?
We can make it work, Your Honor.
Would 10:30 work for the tenants?
Yes,
Yes,
ma'am.
ma'am.
Thank you.
You're welcome. We will set this for May 21st at 10:30 in the morning.
Yes, ma'am.
All right, anything further on this matter, Mr. Henges?
No, not on this one. No, thank you. Attorney Todd Stewart did ask me to cover one for him.
Oh.
I don't know if you have one on the docket. Short South versus Evans is what he told me.
I think we do, because we had two Evanses.
That one, my understanding is a dismissal.
Oh,
Pardon me, Your Honor. Am I free to go?
Mr. Enriquez, Ms. Horton, or Holton, you may go.
Thank you, ma'am.
Thank you.
All right, the other Evans case, Jennifer, was that dismissed?
I don't have a dismissal here.
So that's, is that what you were saying, Mr. Henges, that you thought it was dismissed?
He asked me to appear for him and let you know that he was planning to dismiss the case.
Oh, okay, well then let's call it and put that on the record. This is the case of Short South Realty Group versus Viana Bianca Evans, case number 21-3396 LT. Counsel, your appearance for the record.
Attorney Leo Henges, P74746, appearing for Todd Stewart.
Thank you. This matter was set for the first hearing in the landlord-tenant matter. I'm just quickly looking through my waiting room. I don't see any names that necessarily say Viana Evans. been a while since I checked, so let's just see. Nope, that's not Rihanna Evans. All right, Mr. Hedges, we have this ready to go for a second hearing on May 21st, but you indicated that this case is going to be dismissed. Is that correct?
That is correct. Attorney Stewart just wanted me to ask if the court will require him to submit a written dismissal, or
Yes.
if a dismissal on the record is enough.
If he could submit a dismissal, it would be greatly appreciated.
I will let him know.
All right, thank you very much.
Thank you.
Have a nice afternoon.
Have a good one.
Mhm. Oh, here's a pre-trial sheet for the. All right, appearing on my screen as Valley. What is your name, please?
Wilfredo Valle, Your Honor.
Wilfredo?
Yep.
All right, it's 3409. All right, thank you.
Hello?
Hello, the court hears you. Is your name Vernetta Thomas?
Vernita Thomas.
All right, ma'am. You can go ahead and mute until the court's ready to call your case.
Okay.
I have someone appearing on my screen as phone number ending in 7108. Can you unmute and identify yourself for the court, please?
Hello.
Hello, is that Miss Brooks?
Yes.
All right, I see you, Miss Brooks. I was asking for phone numbers ending in 7108 to identify themselves for me. Miss Brooks, you can go ahead and mute until we're ready to call your case. I also see Mr. Plaque, who is having some difficulty connecting to audio. Mr. Florian. Mr. Florian, can you unmute? Hello, Mr. Clack. You've got yourself, your audio is working. That's fine. I'm gonna go ahead and mute you until we're ready to call your case.
Okay.
I'm keeping inventory of who's here. Mr. Florian, are you an attorney or a tenant?
I'm an attorney. I'm here on behalf of, in place of Todd Van Eck or Haley Cloud for the Hidden Lake Apartments cases.
Okay.
Is there any way, I know I had a second hearing that was supposed to have already occurred and I just got notice that they're going to start it shortly. Can I be put at the end of the docket?
Sure.
Thank you.
You're welcome. I see you appearing on my screen in two places though, Mr. Florian. Is that on purpose?
I am not sure. I've only got one app going.
Okay, well, you were in two places and now you're only one, so that's fine. All right, so
Okay.
you'll be zooming in somewhere else and then I'll call your case at the end. Is that what you need this afternoon?
Sure. I've got my computer up on the other one. It was supposed to start at 2:30 and I don't know what the delay is for, but that one shouldn't take.
It's only 2:07.
Yeah, I know. Well, I know, sorry. It's supposed to be at 1:30 and it's now
Okay,
2:10.
that's fine.
so-
You can mute and I'll let you know when I need you. I do have someone appearing on my screen as phone number ending in 7108. I still don't know who you are and I can't help you unless I know who you are.
Yes, it's Stephanie McDowell.
All right, hello, Miss McDowell. Thank you.
Yes.
All right, to the tenants that I have appearing on my screen, you have a number of rights, and I am going to go over them with you. If you are here on a termination of tenancy, that is, your lease was terminated by notice to quit, your rights are different from the rights of someone who is here on a non-payment of rent case. You do have the right, if you are here on a termination, to have a landlord or to have an attorney represent you, and the paperwork that you received should have indicated how you can seek legal assistance. You do have the right to a second hearing, or the court may set the matter for trial or mediation. But not all of the distinctions that I'm going to go over for the non-payment of rent cases are the same. If you are here on a non-payment of rent case, we will set at least a second hearing in this matter. And before you leave, the court will advise you of the date and time for that appearance. No judgment will enter today unless the plaintiff dismisses the case without conditions or both parties are represented by an attorney. Because no judgment will enter today, you will have at least 7 days to find legal or financial assistance. If you do not appear at the next hearing, a default judgment may enter against you. Other potential outcomes at the next hearing include a dismissal, a conditional dismissal, a consent judgment, or the court might set your matter for trial or mediation. In landlord-tenant court, you have the right to have a lawyer represent you. The papers you received should have indicated several ways you can seek legal help. You may contact Legal Aid of Western Michigan. I do have a representative here from Legal Aid. If it appears appropriate, I will let you have a conversation with him. You can contact the Grand Rapids Bar Association Lawyer Referral Program, or you may visit the Legal Assistance Center here at the 62B District Court. If a judgment is entered in this matter, you will have 10 days to pay the rent and court cost, to move, or to appeal the court's decision. That is the distinction between a non-payment case and a termination case. If you are here on the termination, payment of your rent will not automatically prevent a writ. COVID emergency rental assistance may be available to you if you are here on a non-payment case. Assistance may be obtained through the Coordinated Entry Agency or Housing Assessment Resource Agency, or from the Department of Health and Human Services, or Federal Help for Homeless Veterans. You do not need a judgment to obtain COVID emergency rental assistance or to apply for assistance with the Department of Health and Human Services. If this matter can be resolved through mediation, the Dispute Resolution Center of West Michigan may be able to assist you. When I call your case, please feel free to speak up with any questions you may have, and I will do my best to answer any questions. All right, the court is calling the case of Kellogg Cove Apartments versus Stephanie McDool, case number 21-3406LT. Mr. Visconti, do you appear on this matter?
I do. Good afternoon, Your Honor.
Good afternoon, and this is a termination of tenancy. And do I have Ms. McDool, can you hear me?
Yes.
All right. All right, the complaint in this matter indicates that the tenancy was terminated by notice to quit. Are there any other details that I need to know, Mr. Visconti?
Your Honor, this is a lease end termination of tenancy. The lease expired, and I believe a lease was attached. A copy of the lease should have been attached to the complaint. The ending date for the lease was April 15th, 2021. The notice was sent on January 13th, 2021, with a request that Ms. McDool vacate by April 15th. So it's a very straightforward lease end termination, Your Honor.
Are you seeking a money judgment in this matter?
No, Your Honor.
All right, so this is for possession only. Ms. McDool, what are your plans? Are you going to move?
I spoke with the SARA program. I spoke with the leasing agent over at Kellogg to try to renew my lease. And they have gave me no reason why they are terminating my lease and why I could not renew it.
Well,
Yes.
leases have an end date ordinarily. I haven't reviewed all of the terms of yours specifically, but at the end of any prescribed period, it is the landlord's right to recover their property. And so I do find that the pleadings are sufficient here and that they served you the appropriate notice to quit. I am required to set this matter for a second hearing, and you may continue to negotiate with Sarah and or the landlord, but it will not guarantee that you will not be evicted. We're going to set
Okay, I
this.
did give them the CDC declaration to
Right.
stop eviction because at this point I don't have a plan. I've been looking for a place and I've been having an extreme hard time seeking
Ms.
new
McDowell,
housing.
I know a little bit about that. I do. But the CDC declaration only applies in cases where the landlord is seeking possession based on non-payment of rent. And this is not a non-payment of rent case at this time. I feel like Mr. Visconti, she was here once before on a non-payment of rent. Is that correct?
Your Honor,
can you say that again?
I don't have that in front of me right now. If you give me a moment, I can certainly search and see if we had a non-payment.
Probably knows. Ms. McDowell, did they bring you to court once before?
Yes, and that's when I got with the SARA program.
Yeah. However, this is a different case and this is a different theory. And this is again that your lease has ended. So we're going to set a second hearing in this matter. It's going to be May 21st at 2:00 in the afternoon. Ma'am, you need to be seeking someplace different to live. Do I have Mr. Henry back? It looks like no. If you would like to wait, Ms. McDowell, I can let you have a conversation with Mr. Henry from Legal Aid. He might be able to give you some additional assistance.
Okay, thank you.
You're welcome. Just draw my attention to it if he comes back and you're still waiting. I'll keep an eye out. He's been meeting with another person for quite some time.
Okay.
Anything further on this matter, Mr. Visconti?
Nothing further, Your Honor. Thank you.
Thank you. Jennifer, did I put my docket sheet in that file? Will I just hand it back to you? Yeah. All right, the court is calling the case of. I'm gonna have to wait on that one. Mr. Florian isn't here. All right, the court is calling the case of Ashton Woods Apartments versus Vernetta Thomas, case number 21-3414LT. Mr. Visconti, are you here on this?
Yes, Your Honor, I am.
All right, and I believe that I had Vernetta Thomas.
Yes.
Ma'am, do you have a video that you can turn on?
Hold on just a minute. There you go. Sorry. Yeah. Yes, Your Honor.
Oh, there you are. All right. All right, Ms. Thomas, this is a complaint for non-payment of rent. The court has been provided information that indicates rent to retain possession is currently $958, including court costs of $206. The plaintiff is seeking a possession judgment of $1,164 in this matter. Do you have any reason to believe that those numbers are incorrect?
No,
Is there any reason you haven't paid other than simply not having the money at this time?
for one reason, I didn't have the money because I'm not able to work.
Mhm.
I have some medical problems going on with me.
Okay.
And then I did apply for the COVID rental assistance program.
You said you did?
Yes. So I'm waiting, from to hear from them.
So you applied for COVID emergency rental assistance, Sarah?
Yeah. Yes, ma'am.
All right, Mr. Visconti, that means we're required to stay proceedings in this matter.
And tell them you did the momentary thing. For
And then I did the monetary application as well.
All right, then here's what we're gonna do. We're gonna set this for another hearing. We're gonna set it for approximately 45 days out from today. I'll get that date from my clerk. By that
Okay.
time, either
Okay.
that funding will have come through and this matter will have been resolved, or it will be ripe for a judgment to enter at that time. Give a
Your
date.
Honor,
Yes,
we have not yet received that Sarah application for Bernita that she said she filled out. If she can make sure that she gets that to us, we can have our corporate office fill it out and get it completed.
Ask them what's their email.
What is your email, sir?
It's gonna be manager at Ashton Woods
Okay.
- A as in Apple, P as in Paul, T as in Tom.com.
See, I didn't put the APT.
Okay.
So you can-
Because I didn't put the APT in there. I'm sorry.
Okay. Yep. Once we get that, I'll forward it to our corporate office.
Okay.
All
All
right.
right. I sure will.
we are gonna set a second hearing in this matter for July 2nd at 8:30 in the morning. We'll send notice out.
2 at 8:30. Thank you, Your Honor.
Thank you, Mr. Visconti.
Thank you so much.
You're welcome, ma'am. You may go.
Thank you.
All right, the court is calling the case of, well, Mr. Florian, are you back to join us?
Yes, I am. Thank you.
Okay. The court is calling the case of Hidden Lakes Apartments versus Joseph Plaque, case number 21-3410 LT. Mr. Florian appears on this matter, and I have Joe Clack appearing on Zoom. Can you hear me, Mr. Clack? All right, I'll need you to unmute. All right, Mr. Clack, just 1 second. I see Mr. Henry is back. Welcome back, Mr. Henry. I have Miss Stephanie McDougal who would like to speak with you, and so she's on a telephone, but I'm going to move her into your conference room and move you into that conference room as well so that you can have a conversation. Miss McDougal, you will not be able to get back because you're calling in through a phone.
Okay.
Oh, hold on. Okay, I got it now. All right, Mr. Clack, the court has been provided information that indicates rent to retain possession is $2,744. And I think that says 2 cents, including court cost of $156. The plaintiff is seeking a possession judgment of $2,900.02. Do you have any reason to believe those numbers are incorrect?
I was just looking because our paperwork says 1,100, so I wasn't sure. That would have been yeah, but that wouldn't be $2,900.
Mr. Florian, can you speak to that? Do we have another month's rent that's accrued?
So in the documents that I have rent for April being $1,134 with a late charge of $35 and admin fee of $76 and utility fees of $129.02. And then I have a May rent for $1,134. The late charge is $35. The admin fee of $76 and property damage of $125. And then the filing fees, costs, and service.
And so I'm looking at the complaint, and I don't know who you are, ma'am, with Mr. Clack. What is your name?
Angela Plaque, his wife.
Ms. Clack. I'm looking at the complaint, which is probably what you're looking at, that says total rent due now is $1,134. But you'll also note that that says above it in 5C that rent is paid through March 31st. So through March 31st, the balance was $1,134. You now have additional charges of April and May that have accrued.
Okay. And then we have 2 court costs or just one? One court. The way you make it sounds like we have 2 court costs.
Court cost is comprised of the filing fee, service of process, which is getting you the paperwork, and the attorney's fees, which is limited to the statutory amount of $75. All told, in your case, at this point, it's $156 for court costs.
Okay. Because last month they charged us for court costs too. And we didn't. That's what I'm saying. We got charged for both months for court costs, and we didn't go to court last month. When he said the 76 for the admin, and then another 76 for the court court filing fee.
Who's here on Hidden Lakes? Who's the property manager?
It'd be me.
All right, Miss Haight, are you able to speak to that?
Yeah, it states in their lease, the $50 late fee goes on the 4th. The admin fee goes on the 11th if they still have not paid. they have the filing fee, process server, and then they have yet to be charged for the hearing. I think where their confusion is coming from is they were charged for broken blinds on the property. They have to be changed out. So that's what the extra charge is.
And certainly, Mr. and Mrs. Plaque, you can consult the ledger at any time to make sure that your information, the information that you have is the same. I'm certain that Ms. Haight would go over it with you if you set an appointment with her and give her a call after today. So as the amount that's due, is there any reason you haven't paid other than you just didn't have the money at this time?
We didn't have the money at this time. We did apply for the Sarah on the 25th.
All right, have you received that application, Ms. Haight?
We did, and we completed our portion. We're waiting for the status update.
All right.
They said it should be a couple days. I called a couple days ago because I kept checking it, no update, and they said it should be any day now that we should hear from them.
Okay, so we're going to set this case for a second hearing, and we're going to set it at approximately 45 days from today. By that point, either your Sarah funding will have come through and this case can be resolved, or it will be ripe for a judgment. I think we're setting those on July 2nd. Is that correct, Jennifer? All right, July 2nd at 8:30 in the morning. Anything further on this matter, Mr. Florian?
I don't believe for this matter. Thank you.
Thank you.
Oh, we did have a declaration too. I don't know if that matters, that we had to mention that they did tell us to mention that we need to fill out the declaration too.
Okay, yep, you can send a copy of, did you send a copy of that to the apartment manager?
Yeah, they have that on file.
Okay, yep, she's shaking her head, yes. All right, then you are all set. You may go.
Thank you.
All right, the court is calling the case of Hidden Lakes versus Wilfredo Valley, case number 21-3409 LT. Mr. Valley, are you still with me?
Yes, I do.
All right, the court has been provided with information in this matter that indicates rent to retain possession is currently $3,125, including court cost of $156. The plaintiff is seeking a possession judgment of $3,281.10 in this matter. Do you have any reason to believe that those numbers are incorrect?
Yes, because my paper that I received say another amount.
Okay, is that the complaint that you're looking at?
That's one of those. The other one is I don't working right now.
Okay, so I do note that the complaint in your matter says that total rent is that was due at that time, which was through February 28th, was $1,461.10.
Exactly. Correct.
Since then, there's a balance for March, a balance for April, and a balance for May. So if you add all that together, do you think that those amounts are still due?
Yes, I know it's due.
Okay. Well, I'm glad to hear that you're working. That's good. Is the reason that you didn't pay previously just because you didn't have the money, or was there some other reason?
No, I don't got the money.
All right, could you stop walking around, sir?
Yo, give me 1 second. I just open the door.
It's incredibly distracting for the court.
My bad.
All right, are you seeking any financial assistance?
The unemployment.
Okay.
It's my only source of income right now is the unemployment, and I got issue on my case, and I'm still waiting on that.
With unemployment, you're having an issue?
Yeah, on my case.
Are you, have you applied for assistance through Department of Health and Human Services or any other agency?
No, I don't got any. I don't know. I don't know where I need to apply with that.
Okay, well, here's what I will do. We'll start with Ms. Hampshire because she's here and she can assist you,
Okay.
especially because it sounds like you're working. That might be a good fit. We'll set this for a second hearing. It'll be May 21st at 2 o'clock in the afternoon. That'll be the date and time that you need to come back. And then I'm going to move you into a breakout room with Miss Hampshire. And she's from the Department of Health and Human Services, and she can analyze your situation and see if potentially there is some aid or other resources that are available to you in terms of financial assistance, okay?
Thank you, appreciate it, Your Honor.
Mr. Florian, anything else on this matter?
I don't believe so. Thank you.
Thank you. All right, watch your screen, Mr. Valley, for an invitation to join this breakout room. I thought I had Sabrina Brooks here, but now I don't see her. She's back in my waiting room. L. Brown Figures.
Yes, ma'am.
All right, you are Lee Brown Figures?
Yes, ma'am.
All right, give me just a moment. Mr. Groendyke,
Yes, Your Honor.
you have been sitting there patiently all this time for all of these failures to appear. I'm so sorry. Why did you?
We have.
I am so sorry. I wish you had said something. I'm only now noticing that we had this handful for Wingate.
Well, I thought you just had a very busy docket at 1:30, and we're, just working through that case call.
We did a heavier docket, but I think we should have called your matters by now.
Okay.
Let's see, you have 3?
I do.
Is that right? Or 4? This one was dismissed.
4, yeah, well, we had one that was dismissed, which would leave us with 3.
Okay. All right. Larry Phillips, Deodra Taylor, and Ateria Trimble. And the people who are waiting in my waiting room yet are none of those people. All right. The court is calling the case of Wingate Apartments versus Ateria Trimble, case number 21-3405 LT. Mr. Groendyke appears on behalf of Wingate, and Ms. Trimble has, you are not Ms. Trimble, correct? Ms. Trimble has not appeared in this matter. The court has information that indicates rent to retain possession is $1,626, including court cost of $157. The plaintiff is seeking a possession judgment of $1,783. Service was substitute in this matter, and so we'll have to set this for a second hearing. It will be May 21st at 1:30 in the afternoon. Does that cover it on this one, Mr. Groendyke?
That would, Your Honor.
And the court is calling the case of Wingate Apartments versus Deodra Taylor, case number 21-3404 LT. In this matter, the court's been provided information that rent to retain possession is $1,573.99, including court costs of $157. Plaintiff is seeking a possession judgment of $1,730.99. Service was posted in this matter, and so we will schedule this for a second hearing, May 21st at 1:30 in the afternoon. Anything further on this matter, Mr. Grondike?
No, Your Honor.
Thank you. And last, the court is calling the case of Wingate Apartments versus Larry Phillips, case number 21-3402 LT. Did I just do that one?
We've got Taylor, Trimble, and Phillips.
Right, we did.
Good afternoon.
Which two do you have?
I have Taylor and I have Trimble.
Taylor and Trimble. This is Phillips, Nancy. Did you hear me call Larry Phillips and go over his information before, Mr. Grondike?
I don't think so, Your Honor.
Okay. All right, that's okay. All right. This is Wingate versus Larry Phillips, case number 21-3402 LT. The court has been provided information that indicates rent to retain possession is $2,108, including court costs of $157. Plaintiff is seeking a possession judgment of $2,265. Service was posted in this matter, and so we will set this out for a second hearing. It will be May 21st at 1:30 in the afternoon. All right, Mr. Grondike, do you have anything else with me this afternoon?
No, that was short after that wait. So
it was short and sweet. And again, I apologize if you had spoken up, I would have gotten you out here closer, maybe to 2 than 2:30. But
well, I said it in enough Zoom hearings where people just kind of butt in and say, "Is it my case?" or start talking, and I just figured we'll work it through the docket. So next week at Friday at 1:30, then I'm sure I'll be the first case called.
Absolutely, I will make sure of it, Mr. Grondike. Thank you so much for your patience and your courtesy. Have a nice afternoon.
Thank you. Have a good weekend.
Hello? Hello?
Ms. Brooks, I can hear you. You were here and then you were gone again. Ms. Brooks, can you hear
Crazy
me?
charge, I'm sorry. Yes.
All right, the court is calling the case of Ashton Woods versus Sabrina Brooks, case number 21-3417 LT. Ms. Brooks, you were here when I went over the advice of rights, correct? That was at the very beginning. I had a number of people here and you were able to listen to that?
Yes.
Okay. The court has been provided information that rent to retain possession in your matter is currently $1,891, including court cost of $206. The plaintiff is seeking a possession judgment of $2,097. Do you have any reason to believe those numbers are incorrect?
No.
Any reason you have not paid other than you just don't have the money right now?
Yes.
What is that reason?
Oh, no, because I don't have the money.
Just because you don't have the money? Yeah, it's just a matter of financial hardship. A lot of people are in that position. Are you applying for any financial assistance, ma'am?
Yes, I'm actually, I had got I believe it's called a CDC paper.
All right, CDC.
Because I'm getting help.
Well, the CDC declaration in itself does not provide financial assistance. Have you applied through the Department of Health and Human Services or through the COVID Emergency Rental Assistance Program?
It's through the Salvation Army, like COVID help.
That would be Sarah.
Okay.
All right.
Yeah, I have my Sarah number and stuff.
All right. Who is the property manager in Ashton Woods?
I'm
It's
right
Ryan
here.
Reynolds,
We
Your Honor.
yeah, we have received that application.
Okay. All right. So
Have
we're,
you submitted your landlord application, Ryan?
Yeah, our corporate office takes care of all that. They were forwarded it probably 2 or 3 days ago when I first got it.
Okay.
all right. So we're going to have to stay proceedings in this matter. Then we'll set this up for a second hearing. Let me just confirm with my clerk that that'll be July 2nd at 8:30.
Thank you, Judge.
You are welcome. All right, ma'am, that'll be the next date and time that you need to appear in court. Either your Sarah funding will have come through or this matter will be right for a judgment at that time.
Okay, and you said July 2nd
Yes,
at 8:30?
correct.
Okay. July 2nd.
And you may go, ma'am.
Okay.
All right, the court is calling the case of Ashton Woods versus Tiffany Swift, case number 21-3415 LT. Mr. Reynolds, nice to see you. Thank you for turning on your camera.
Yeah, you're welcome.
All right, do I have Tiffany Swift here? All right, the court has been provided information that rent to retain possession in this matter is $1,809, including court costs of $206. The plaintiff is seeking a possession judgment of $2,015. Service was personal in this matter, it appears. Mr. Reynolds, do you know whether or not they are still occupying this apartment?
She's not going anywhere. She's still there.
All right. Mr. Visconti, how are you asking the court to proceed today?
At this point, Your Honor, I would ask the court to enter a default judgment for possession only in the amount stated on the affidavit, and I'd be happy to voir dire my client if the court deems that necessary.
Yes, we will have to have that. Mr. Reynolds, can you raise your right hand? And do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, Mr. Visconti, you may inquire.
Thank you. Ryan, can you state your name for the record?
Ryan Reynolds.
You're the manager of Ashton Woods Apartments?
Yes, I am.
You have knowledge of the books and records of the property as it relates to the tenancy of Tiffany Swift at 4613 Drummond Boulevard, Southeast, number 301?
Yes, I do.
And that property is located in Kentwood, Michigan?
Yes.
Is Ms. Swift presently in arrears to the community in the amount of $1,809 through the month of May?
Yes.
You have $206 in court costs?
Yep.
So you're seeking a total possessory judgment today of $2,015?
That's correct.
To your knowledge, is Ms. Swift a minor, member of the United States military, or otherwise incompetent?
No.
Has the premises been kept fit for its intended use?
Yes, it has.
Has Ms. Swift provided the community with a CDC declaration?
No, she has not.
And to your knowledge, has there been a SARA application submitted by Ms. Swift?
No, there is not.
Based on the foregoing, Your Honor, I'd ask the court to enter a default judgment for possession with the writ to issue after 10 days.
All right, I do find the pleadings are in order and a default judgment will enter. I don't have a proposed judgment here, Mr. Visconti. If you can send one over, I'll get it signed.
I will do that this afternoon. Thank you, Your Honor.
All right, thank you. All right. What is your name or what matter are you here on?
My son, Isaiah Williams, he, even though he had to go to court on the 27th, and we didn't want his lawyer, nothing, so he wanted to plead guilty to get it over, you know.
All right, we're gonna have to wait on this one. All right, I'm sorry. I'm gonna finish my landlord tenant docket before we address that. All right, Mr. Brown figures.
Yes.
Were you here initially when I went over the advice of rights for tenants and landlords?
Yes.
I thought so. All right, the court is calling the case of Breton Court Apartments versus Leroy D. Brown Figures, case number 21-3411 LT. In this matter, the court has been provided information that rent to retain possession is currently $2,539, including court cost of $226. The plaintiff is seeking a possession judgment of $2,765. Do you have any reason to believe that those numbers are incorrect, Mr. Brown Figures?
Yes. Me looking at this paper in front of me, it has it as $1,786. And when I did receive the assistance from the DHS, initially they were going to pay, I want to say it was $1,100, but then they actually increased it to the complete balance last time. So it should actually have taken care of more of what I owed previously. And I did make a payment towards my rent.
All right,
Prior to this date as well.
So the amount that you stated that's on the complaint was the amount due through February 27th of 2021. Mr. Bollinger, can you give us a breakdown?
That is correct. The current balance that's been stated is correct. He did get a payment from DHS of $1,040, and that was done back on the end of April. Mr. Figures did pay back in March of $800, but has not paid since. So the current balance is correct.
All right, Mr. Brown Figures, are you seeking any additional financial assistance?
I guess I'll just have to contact the DHS again because the complete amount that I asked for previously was not met. They did not pay. They didn't help me with the complete balance I was due previously because he just said they only paid $1,100. What it really should have been, I want to say closer to $2,000 what I owed previously. So I guess I will contact them and see what help I can get with the remaining balance. And I know I will be going back to work this upcoming week, try to get that money paid.
Okay. All right, well, here's what we're going to do. And I can let you speak with Ms. Hampshire if you want to wait. She's currently meeting with someone else, but when she returns, you can meet with her and you can ask her about your prior application. And I don't know if maybe for this new and separate case or different circumstances, different time period, you might need to do another application or seek other avenues. But I can let you speak with her shortly. We'll set this matter for a second hearing. It'll be May 21st at 2:30 in the afternoon.
Thank you, Your Honor.
Thank you.
All right, Mr. Brown Figures, if you sit tight. Well, actually, Ms. Hampshire is back. And so
Okay.
I can move you into her breakout room right now to speak with him.
Thank you.
Ms. Hampshire, I have Leroy Brown Figures who'd like to speak with you. I think he has a prior case. He has some
Yes.
questions.
Okay, thank you.
Where's Miss Johnson? She was just here. Can
I
you?
know, I did saw her. She's disappeared.
Ugh. All right, well, I don't see any other tenants. Who else was set at 2:30? Let's see if she- we can
Max
do-
Devil Me,
Devil Me.
3412.
Say that.
It's literally, it's DEVILME is the last name.
Yeah.
Devil
It is
Me
correct.
Devilm or Devil Me? I mean, it's really only, huh, okay. Mr. Bollinger, you said it's Devil Me?
That is correct.
Okay.
I was really phonetic about that, but
All right, the court is calling the case of Breton Court Apartments versus Maxo Devil Me, case number 21-3412LT. This matter was set for the first of two landlord-tenant summary proceedings at 2:30 this afternoon. It's 2:54 and I haven't seen anyone by that name appear in my Zoom waiting room or in my courthouse. Service was personal in this matter. Mr. Visconti, are you seeking a possession judgment today?
I am, Your Honor.
All right. All right, and Mr. Bollinger, you appear on behalf of Breton Court, correct?
That is correct.
All right, can you raise your right hand, please? And do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may inquire of your client, Mr. Visconti.
Thank you, Your Honor. James, can you state your name for the record, please?
James Bollinger Jr.
And you're the manager of Breton Court Apartments?
That is correct.
You have knowledge of the books and records of the property as it relates to the tenancy of Maxo Devil Me at 4689 North Breton Courts, Southeast, number 100 in Kentwood?
I do.
And you sent an updated affidavit to our office earlier today, is that correct?
That is correct.
And that reflects a current arrearage of $848.85, correct?
Correct.
And then you show court costs of $216?
Correct.
For a total redemptive amount of $1,064.85, is that correct?
Correct.
To your knowledge, is the defendant a minor member of the United States military, otherwise incompetent?
No, he's not.
Has the premises been kept fit for its intended use?
Yes, it has.
Have you received a CDC declaration from this individual?
I have not.
To your knowledge, has there been a SARA application that's been submitted by this defendant?
To my knowledge, no.
Based on the foregoing, Your Honor, we would ask for a default judgment for possession with the order of eviction to issue after the 24th if not paid in full.
All right, thank you, Mr. Visconti. I am looking at this updated affidavit dated 5/14. It is for a total possession amount of $1,054.85. When you gave your testimony,
I'm sorry.
it was
I'm sorry. I think I had the court costs wrong, Your Honor.
Yeah.
All right, and so the court costs are what?
206 rather than 216. My handwriting is not helping me today. So
You should see mine, Mr. Visconti. You really, these clerks, every clerk in this courthouse has had to learn a whole new language since I took the bench. All right, so a default judgment will enter in the amount of $1,054.85. You can submit that this afternoon, Mr. Visconti, and we'll get it signed.
Thank you, Your Honor.
Thank you. All right, the court is calling the case of Breton Court Apartments versus Gregory B. Davis, case number 21-3425LT.
That's not mine, Your Honor.
That's not Breton Court, I don't think.
It's not. Did I say Breton Court?
Yes, you
did. You did.
Oh, that's because on my pretrial statement that we generate in advance, it says Breton Court, but this is Hunter's Ridge. That's okay. That's okay. Who's here on Hunter's Ridge? All right, crickets. Let's.
Not to my knowledge. Was this from last week, Your Honor?
This is a first hearing. I have the original summons right here in front of me, dated 5/14, 2:30 in the afternoon.
I believe that's my office, Your Honor, that handles Hunter's Ridge, unless there's been a change of ownership.
It says Jarrett Levine on it.
Yeah, I don't have that case set for today.
It's a non-payment of rent. It was filed 4/21. I guess what we'll do then is just since nobody, well, certainly Mr. Davis isn't here, and since the plaintiff doesn't appear to really be here either, we will just adjourn it out to another date. We can go ahead and keep the date that we generated, which was May 21st at 2:30 in the afternoon. And if something needs to change on that, Mr. Visconti, you can let us know.
That's fine, Your Honor. Can I get the case number on that, please?
21-3425 LT.
And that's going out to the 21st?
Yep, 5/21 at 2:30 in the afternoon.
Thank you, Judge.
All right, Ms. Johnson still has not rejoined us. And I only have her and, let's see. All right, the court is calling the case of Hidden Lakes Apartments versus Yama Peewee, case number 21-3407 LT. Mr. Florian, this is your last matter this afternoon, correct?
That is correct, Your Honor.
All right, I don't have anyone who appears by that name in my courtroom or on my Zoom screen. The court has been provided information that rent to retain possession is $1,323.59 with court cost of $156. Plaintiff is seeking a possession judgment of $1,479.59. Service was posted in this matter, and so we will set this for a second hearing. It will be May 21st at 2 o'clock in the afternoon.
Thank you very much.
Thank you, Mr. Florian. Nice to meet you. Have a nice afternoon.
Nice to meet you as well. You too.
All right, the court is calling the case of Breton Court Apartments versus Kenesha Johnson, case number 21-3413 LT. Mr. Visconti, you appear on this matter, correct?
I do. Thank you, Your Honor.
And Ms. Johnson was with us for a brief period of time via Zoom. We all saw her, and now she is off of the screen. The court has been provided information that rent to retain possession is $2,286 with court costs of $206. Plaintiff is seeking a possession judgment of $2,592. Service was personal in this matter, but she attempted to appear. And so I think this court is going to leave it on for 5/21 at 2:30 in the afternoon for a second hearing.
No problem with that, Your Honor. 5/21 at 2:30.
We'll send her a notice that she can appear in person. Maybe that will be better for her.
She might have been working and then running late or something.
Could be any number of things, Mr.
Yeah.
Bollinger. All right, so that's it then for today, correct, Mr. Visconti?
Yes, Your Honor, it is. Thank you so much.
All right, have a nice afternoon, a nice weekend, all of you.
Take
You
care.
as well. Thank you.
All right, the court is calling the case of the city of Kentwood versus Isaiah Williams, case number 21-500080M. Come on up to the lectern, Mr. Williams. All right. Sir, in this matter, the city of Kentwood alleges that back on December 31st of 2020 in the city of Kentwood, County of Kent, you were a disorderly person. That is a misdemeanor. It is punishable by up to 90 days in jail, a fine of $500 plus court costs. Do you understand the charge and the maximum penalties?
Yes.
All right. When you were arraigned on this matter, you pled not guilty, and an attorney was appointed for you. We later learned that there was a conflict with that attorney, and so substitute counsel Denise Buswa was appointed to represent you. I reviewed your file. I verified that we sent notice to her at the correct address, and we did. I also recall that she was here on the date of your pretrial conference when you failed to appear. She zoomed in, but we didn't see you, and I don't believe she'd had any contact with you. And so we didn't see you at the pretrial conference on April 14th, sent you an order to show cause for April 27th, and that would have gone directly to you at 904 Griggs. Is that where you live?
Yeah.
And then you didn't appear. Why not?
Actually, I thought I was talking to my lawyer first, and I thought she would email me the day to come in, but I never received the email. So,
But did you get the mail?
no, I'm not sure. No.
All right, well, we have 904 Griggs Street, Grand Rapids, 49507. Is that your address?
Yes.
Okay. I recognize that you were relying on your attorney, and if she didn't contact you, that must have been unsettling because she is supposed to be in contact with you. But we would have sent the order to show cause directly to you as well so that you would know. And so for future reference, if you get notice to come to court, come to court. Your attorney will likely meet you here, and if they don't, they will be the one in trouble and not you. Because in this matter, a bench warrant was entered because you failed to appear. Here's what I will do for you today, sir. I'm not going to let you tender a plea to the court. We'll continue your not guilty plea. We'll recall the bench warrant. We'll set this out for another date. And you can get in touch with Miss Buswa. I am looking at her data entry fields on the State Bar of Michigan website to confirm her address and her information so that we know we sent her notice to the right place. I will write down the contact information for you here so that you can be in contact with her. Have you been in email communication with her previously?
She emailed me one time, and she was like, we changed the addresses, something like that.
Okay.
And, and she sent me like the police report.
Okay, so you have her email address. All right, I don't have a clerk in here, so I'll have to take your file down to the clerk's area to get you a date generated for today, sir. You may approach. I'm going to give you some contact information for Ms. Buswell so you can get in touch with her. All right, if you'll go down to the clerk, someone will meet you at the counter with the date and time of your next pretrial conference, okay? Thank you.